ladies and gentlemen, welcome to the final panel in a wonderfully substantive and illuminating series of conversations. So, as you've heard so far, there is a vigorous debate about whether school reform should focus more on increasing funding or on changing incentive structures, including those related to teachers' unions. And what we're about to do now is discuss the most important constitutional case in the country, in which a state court has held that the California Constitution's guarantee of equal educational opportunity forbids certain teacher tenure rules, including last in and first out, on the grounds that that denies to poor kids an equal educational opportunity. There's a vigorous debate about the merits of this decision. There are similar decisions bubbling up in New York and New Jersey. So to the degree that the school choice question is going to be settled constitutionally, it's going to turn on the arguments that you hear today. We are incredibly honored to have the leading advocates in the country, the two gentlemen who actually argued this case before the California courts. They are among the top advocates in the country. They are cordial adversaries, but they've sort of argued side by side, and they've flown all the way from California to talk to us, so this is a real thrill. Let me introduce them, and then we're going to hear a great discussion. James Finberg is a partner at Altshuler Berzon and represented the California Federation of Teachers and the California Teachers Association in this case, which is called Vergara versus California. He was a law clerk to Justice Charles Levin of the Michigan Supreme Court and past president of the Bar Association of San Francisco, named the best lawyer in the Labor and Employment Lawyer of the Year of San Francisco in 2014. Joshua Lipshutz is a partner at Gibson, Dunn, and Crutcher. He has represented clients before the Supreme Court of the US. He was a law clerk to Justice Scalia on the Supreme Court and Judge Alex Kozinski on the US Court of Appeals for the Ninth Circuit, and he was selected in 2015 as a rising star appellate attorney under 40 by Law 360. Ladies and gentlemen, please join me in welcoming James Finberg and Joshua Lipshutz. Welcome. Gentlemen, thank you so much for making the trip. Let us jump right into it. Joshua, tell us about the facts of this Vergara case. How did it come to be, and what's the current state of it?
So, thanks for having me, and this is a great opportunity to tell about this case, this important case, and thanks to everyone for attending. So in the 1970s, the California Supreme Court declared, in some ways unlike the Pennsylvania Supreme Court, that in California there is an enforceable fundamental right to education in the California Constitution. The California Supreme Court called it the right to equal educational opportunity. And in that case, in the 1970s, the case was called Serrano. The question was equal funding, whether there needed to be equal funding among the various schools and school districts throughout California, and the California Supreme Court said that there did. Years later, in another decision called Butt via the state of California, B-U-T-T, an unfortunately named case, the California Supreme Court decided that time in school was also essential to having an equality of educational opportunity. So in that case, one district in Northern California was decided that they needed to close their doors early because they had mismanaged their funds over the year. And the California Supreme Court ruled that that was a constitutional violation because they were depriving children in that district of substantially equal time in school as compared to other kids in California. In this case, in the Vergara case, we challenged a series of California teacher job protections as directly harming students in California. And it's really the first litigation of its kind. What we argued before the trial court, and what we will argue and are arguing currently before the appellate courts, is that the California fundamental right to equality in educational opportunity does not only mean equality in money and equality in time in school, but you can't have substantially equal educational opportunities across the state of California unless all students have access to at least minimally effective teachers. Teachers of minimal competence, teachers that are not failing their students year after year after year. Over the last few decades, we've learned through a lot of different studies, and there's pretty much universal agreement on this, and I'm sure my good friend Jim on the other side will agree as well, that of all of the in-school factors that affect student outcomes and performance, teachers are the most important factor. So which teachers a student has during the course of their K-12 career and how effective those teachers are determines whether students, more than any other in-school factor, determines whether students succeed or fail, and often failure can lead to what's commonly referred to as the school-to-prison pipeline, unfortunately. So we traveled around the state in putting this lawsuit together. We traveled around the state and we spoke to students, we spoke to parents, we spoke to teachers, principals, superintendents, officials with the State Department of Education, and we asked them, what is preventing you from putting a high quality, or at least minimal quality, teacher in every classroom across California? And what we heard across the board, almost universally, was the number one thing people identified was California's teacher tenure and job protections. And these are, let me start off by saying that nobody in our case at least, is against the concept of tenure as a concept. Tenure may have a place in public education, it may not. That's really not what this case is about. But California's teacher tenure protections are really quite unusual in the United States. So when a teacher becomes a teacher in California, they are granted tenure within 16 months of being on the job. So halfway through their second year on the job, the school district has to decide at that point whether or not they will have lifetime tenure. Permanent employment is what the statute itself calls it. That's simply not enough time to determine whether a teacher, and every school administrator that we spoke to that testified on our behalf at the trial, and frankly many of the witnesses on the other side of the trial, agree that that is just not enough time to determine whether a teacher is going to be any good over the course of their career at teaching children, and actually imparting knowledge on children. California also has probably the most stringent teacher job protections, called the dismissal statutes in our case, that prevent school districts from terminating teachers who have proven themselves to be ineffective at teaching students. There are nearly 300,000 teachers in the state of California, and I'm wondering if anybody has a guess as to how many teachers in California are fired for poor performance in any given year in California. Does anyone want to hazard a guess? Hearing a lot of guesses. 2. There are 2 teachers per year, and to be fair, it's 2.2 teachers. 2.2 teachers per year out of nearly 300,000 in the state of California that are fired for poor performance. And the reason for that is quite simple. The laws make it almost impossible. School districts, including the Los Angeles Unified School District, testified at trial, and the evidence was really unrebutted, that it costs between $100,000 and $300,000 on average to fire a single teacher for poor performance. And so it just doesn't happen. Districts don't have those kinds of resources. They can't pour that kind of time and money into the dismissal effort. And then finally, California has an unfortunate set of laws that we called the LIFO layoff laws, last in, first out. And these laws are shared by a number of other states around the country, and I should have checked. I'm not sure whether Pennsylvania shares this law or not, but New Jersey does, New York does. And what it means is that in a time of budget cuts, when teachers have to be laid off, and this is something that nobody wants to do, but unfortunately because of the budget situation or because of declining enrollment in any particular school district, teachers have to be laid off. The school district has no say, essentially no say, in whether they lay off, in which teachers they get to lay off. They have to lay off the most junior teachers first, regardless of how good those teachers are at teaching students and how loved they are by their students. And it's actually not uncommon in the state of California for a teacher to be named Teacher of the Year within their school district and laid off the same year because they don't have the seniority to withstand a last-in, first-out layoff. And that's really, in the words of the judge who made the findings in the case, it's really inexplicable. And it's not supported by any kind of logic or common sense. A school district needs to be able to manage its workforce in a way that maximizes opportunity for its students, not constrained in the way that it conducts its performance evaluations, its layoffs, its hiring, and prevented from putting the best teacher in every classroom. As a result of last-in, first-out layoffs, there were some schools in California over the last few years, particularly schools that serve high-poverty communities, that were forced to lay off up to 90% of their teachers in a single year, while other schools within the same district that serve more affluent communities were not forced to lay off really any teachers. That's not a way to run a school system. And what we argued to the court, and what the court agreed with us on, is that the California Constitution requires far, far better than that. The California Constitution requires that the California school system be managed with the interests of students in mind first. It's not a system it's not a system that's meant to provide jobs for adults. The purpose of education is to provide education for students.
Thank you so much for that great introduction. Jim, what do you disagree about in Josh's account of the facts? And in particular, are you persuaded by his claim that these LIFO laws and other tenure laws funnel the worst teachers to the poorest kids?
Well, let me start with where I agree with him. I agree that California does have a right to educational equality, and I agree that having strong public schools is incredibly important. The problem with Josh's approach is that they're attacking the wrong problem and offering the wrong solution. California spends almost the lowest in the nation on per pupil funding. California needs more resources for our schools, and we need to give teachers the support to do the best job that they can. The interests of teachers and students don't really diverge, they align. When teachers are supported and given resources and backup, students thrive. That's what all the studies show. And in fact, the laws that they attacked in this case serve very important purposes. For example, tenure is critical to academic freedom. We had testimony at this trial about teachers who said that they would have been afraid to teach about evolution or be open about their sexual orientation or teach about global warming if they hadn't had the security of tenure, and if they had had to be concerned that certain school board members with certain views could have fired them because of what they were teaching or because of the view that they expressed. So tenure is critically important to a well-functioning system. Now, in terms of when someone gets tenure in California, it's a 2-year initial period during which a school district can terminate a probationary teacher for any reason at all or no reason at all. And the testimony at trial was that a well-run school district shouldn't give tenure unless a teacher had demonstrated during that period that he or she was an effective teacher. And Linda Darling-Hammond from Stanford and Susan Moore Johnson from Harvard testified that the truly incompetent teachers can be identified with that 2-year period, will not have demonstrated that they are truly effective, and so they won't get tenure. But even if a teacher does get tenure, there is a dismissal process in California where someone who is not a good teacher, not doing his or her job, can be written up. And the reason that it doesn't come to a termination for cause is that the system has a peer review mentoring process first. And Professor Susan Moore Johnson from Harvard, who studied that system, said that in fact it works, and that in the districts that she studied, which included schools near Sacramento and down in Southern California, that 100% of the teachers either were mentored to becoming good teachers or left voluntarily. And that's why they don't show up in Josh's 2.2 statistic. So if the discipline and termination system works, then even if some people slip through the cracks in getting the tenure, you can address that through the discipline system. And then in terms of layoffs, nobody should be doing management of who's teaching by layoffs. Layoffs are an unfortunate event. We hope that they don't occur. But when they do occur, you have to be able to act quickly and nimbly in a well-organized, fair, and predictable manner. And that's why Professor Johnson from Harvard testified that in Massachusetts, where factors other than seniority can be taken into account, they in fact do layoffs on the basis of seniority because everybody agrees that it's fair, it's objective, and you can implement it quickly. So I think the unfortunate part of this case is it's a distraction from how we really need to fix our schools. We need smaller class sizes, we need pre-K education, we need more support of teachers, and these statutes, if they were gotten rid of, would harm school districts because, as we heard earlier, we have a teacher shortage now. It is difficult for districts to recruit and retain teachers. Diminishing job security, making teachers at-will employees when they have already low salaries, will make it that much harder for our school districts to recruit and retain quality teachers, which is really what's in the interest of our students.
Great. Okay, we have the facts and the debate is well joined. I now want the audience to understand the best constitutional arguments on both sides. So, Josh, you said that California, unlike the US Supreme Court, but like many states, has recognized a fundamental right to educational equal opportunity that requires some equality of funding. This case, though, is different because it has to do with statutes governing teacher tenure. And a big part of this case was Brown versus Board of Education. The court cited Brown as authority for the idea that everyone in California has an equal right. Tell us more about the relationship between Brown in this case and what was the court's constitutional holding.
So the California Supreme Court, first let me just correct one point, is in Serrano, the case that announced the fundamental right to educational opportunity in California, the case itself was about funding, but the right that the California court described was not tethered to funding. And so the California announced that there is a right to equality of educational opportunity in the state of California. It later applied that right beyond the funding context. As I explained earlier, it applied it to the amount of time that students spend in school, for example. And what the California Supreme Court said is that when a law in California has what's called a, quote, real and appreciable impact on the equality of students' educational opportunities, then that law must be subject to strict scrutiny in the courts. And what that means, that's a kind of term of art among constitutional lawyers, but what strict scrutiny means is that the court must look at the law and the state, it is the burden of the state to prove at court, at trial, or in its papers, that the law is necessary to serve a compelling interest of the state. And so the first thing that we set out to do in this case was to prove that the laws at issue, the permanent employment statute, the dismissal statutes, and the last in, first out layoff statute, have a real and appreciable impact on the equality of education that students are receiving in California. And we did that in spades. The trial judge, we put on, it was a 2-month-long trial, and really our evidence on this point was essentially unrebutted. The trial court found that we met our burden of proof on all requirements, and he found the evidence to be overwhelming. In fact, the trial court found that it shocked his conscience. The way that these laws, the impact that these laws have, particularly on poor and minority students in California. And let me explain the reason why these laws have such a devastating impact on poor and minority students. And maybe it's obvious, but maybe it's not. Because the school districts have no way of dismissing teachers that are not performing as well as they should, and in many cases teachers that are really abusing students' time, showing movies, when they should be teaching, showing YouTube videos, doing crossword puzzles while they sit at their desk. We heard some really horrible horror stories during the course of our trial from our plaintiffs and from teachers themselves. But because districts have no way of dismissing those teachers from the district, what happens is the schools where those teachers are located, the principals in those schools, if they're good managers, will do everything they can to make sure that that teacher doesn't teach in their school. And that results in a phenomenon that's commonly referred to as the dance of the lemons. The teachers who everyone knows can't teach or are not teaching, not willing to teach, whatever the reason is, they do everything they can to move them around the system. And guess where they end up? They end up in schools that are harder to staff because those schools are desperate for pretty much anyone. And those schools tend to be the schools that serve predominantly the low-income and minority communities. We had study after study commissioned for our case, but also studies that were not commissioned for our case. Studies that were conducted by Dr. Raj Chetty of Harvard, Dr. Thomas Kane of Harvard, Dr. Eric Hanashek of Stanford, Dr. Dan Goldhaber of the University of Washington, all of whom testified at our trial that poor kids in particular are being devastated by these laws. In Los Angeles Unified School District, a Latino student is 68% more likely than a white student to be taught by a bottom 5% teacher, a grossly ineffective teacher. Those results are devastating for those students, and they set them way, way back. And so the first thing that we set out to do was prove that these laws have a real and appreciable impact on students. Not really disputed, and frankly, even though we put on a lot of evidence, the trial court did not have any trouble reaching this conclusion. It's pretty obvious that these laws have an impact on students. So then the question becomes, can the state prove that these laws are necessary to serve a compelling interest? And here, with respect to my colleague on the other side, the state and the unions really put on no evidence at all. They never explained to the trial court why these laws, not tenure as a general concept, but these particular laws, this amount of time to tenure, these onerous dismissal statutes, this particular last in, first out layoff statute, why are these laws necessary? Why do we need them? We never heard the answer to that question in 2 months of trial. And as a result of that, the trial court, and by the way, we know that the laws are not necessary because most other states in this country don't have these laws. The California laws in this respect are pretty much an aberration around the country. Most states around the country have 3 to 5 years to get tenure. Most states, it's far easier to dismiss a teacher for poor performance, and in most states, they allow factors other than seniority to be used in determining which teachers to lay off. So we know that the laws aren't necessary. So as a result of that, the trial court found that the state and the unions had not met their burden to prove that the laws are necessary, and he struck them down as unconstitutional. And the laws are currently on, the ruling is currently on hold pending appeal, but if and when we succeed on appeal, these laws will be struck down, and the legislature will have to do what legislatures are supposed to do, which is go back and find another system that works and that doesn't violate the constitutional rights of students.
Great. So, Jim, I'd love the response to the constitutional points. First, Josh has said that the lower court found that you had to apply what's called strict scrutiny, the highest standard of review. Why was the court wrong to so hold in light of the fact that the U.S. Supreme Court, in cases like the Parents Involved versus Seattle School District, both the majority and the dissent seem to assume that some kind of strict scrutiny applied when evaluating this scheme that used race in setting school districts in Seattle. And then second, what's your response to the question that Josh raises? What is the compelling interest in these teacher tenure laws?
The court inappropriately applied strict scrutiny. In order to have an equal protection challenge, one needs to identify a particular group of persons who are affected by the statutes and show that the statutes caused the harm. And the plaintiffs weren't able to either identify a group or to show that the statutes caused the harm. I agree with Josh that there is an achievement gap in this country, and the education of poor minority students isn't as good as for rich white people in this country, and something needs to be done about that. But again, they've identified the wrong problem and the wrong solution. The testimony in this case showed that in well-run districts, people were able to make tenure decisions appropriately and dismissal decisions appropriately, and these statutes worked fine. These statutes treat everyone of every race, color, and economic status equally. These statutes don't assign teachers to any particular school or any particular classroom. So there's no causal connection between these statutes and the harms that are alleged, and that's why they haven't stated a legal claim. And Professor Darling Hammond from Stanford, Professor Rothstein from the University of California, Berkeley, Professor Susan Moore Johnson from Harvard say the way to address the achievement gap, again, is to give resources and attention to these poor inner city schools, to move strong principals to those schools and to support the teachers. Because the phenomenon that Josh is describing about having poor, inexperienced teachers in those schools is because teachers who don't get paid well and are in schools without resources, that don't have books, that don't have heat, that aren't getting any support, leave those schools voluntarily and go to higher social economic status schools. Change those conditions and you won't have that problem. But it's not these statutes that cause the problem. These statutes promote academic freedom and help school districts retain high-quality teachers, which is really in the best interest of our students.
Just to understand the implications of this landmark ruling, the California court held that the California Constitution guarantees a basic level of education that allows children to compete successfully in the economic marketplace and participate in the social, political, and cultural aspects of society. How do courts evaluate whether a school system meets that ambitious standard?
Well, that language actually comes directly from the California Supreme Court. That's the language that the California Supreme Court said is the foundation for the basic constitutional right that exists in California. You know, the purpose of education is to do those very things. It's to enable, it's not to just keep students warehoused, keep kids warehoused for 12 years, and then however they turn out, they turn out. If we're not churning out students on a consistent basis who are able to compete for jobs, who are able to vote in society and know what they're voting on, then that's not education. It might be babysitting, and it might effectively use their time, but it's not education. And so one of the things that we argued in our case was that, you know, you have to look at outcomes. As an education system, you can't blind yourself to the outcomes that you're producing. And really, the laws that the unions and the state of California, sadly, are defending mandate that the system be outcome blind. They mandate that teachers retain their jobs without looking to see whether the teacher is actually producing results in their students. In fact, the state of California, at the urging of the teachers' unions, has made it illegal for the districts to connect student test scores to teachers, so that districts cannot evaluate whether teachers are actually achieving student learning as measured by the state's own tests. These kinds of laws don't make any sense. They're all designed to prevent accountability. And that's where the court really came down. The court came down on the side of accountability. Of course, we all want to have accountable principals. And frankly, if there are principals that are failing in their job and failing to manage the teacher workforce, then they should go too. We're not, this is not a case that's targeting teachers. This is a case about accountability. And the case happens to be about teachers, but the same case could be made for principals. And so what other states have done, to go back to your question, the New York Court of Appeal, the highest court in New York, has used very similar language in determining what constitutes a minimally adequate education in the state of New York. And they've looked at things like graduation rates, literacy rates, college attendance rates, the ability to obtain a job, and the actual value of a high school diploma. And they've looked at all of those things in determining whether the state's school systems provide a minimally adequate education. And by the way, the federal government is beginning to use very similar language, and other states use them too. So these are not tests that the district or the trial court in this case came up with out of thin air. These are tests that more and more we're seeing courts show a willingness to apply because the outcomes across this country are so poor for lots of reasons, not just the statutes that we're challenging, lots of reasons, but in part because of the statutes that we're challenging.
So Jim, are those legitimate criteria for courts to apply in evaluating a minimally adequate education, or conservatives have long criticized liberals for using courts to micromanage the education system from busing to school funding? Is the shoe now on the other foot, and are conservatives doing the same thing?
Well, the California dismissal statute expressly provides that a teacher who is not doing his or her job in educating students can be dismissed. The issue about test scores has to do with the reliability of the test scores. So evaluating a teacher by the test scores of the students of his or her class could mix up the fact that students who have a low economic status are getting lower test scores. And if you don't control for that, you're falsely blaming the teacher. And a lot of these test scores are unreliable. And I think it's significant that in the friend of the court briefs that were filed in this case on September 16th, 100 education scholars, including Diane Ravitch from NYU and Ed Hartle from Stanford and people from all over the country, Duke and UCLA and Berkeley, supported our view as to educational policy about what is good for education. I think as to whether the court should get involved in educational policy, how long a 10-year statute should be. I mean, the plaintiffs seem to agree that 10-year conceptually is appropriate. They seem to agree that due process for teachers, instead of being able to terminate a teacher arbitrarily and for no reason, some due process is appropriate. Given that, I think it might be better for a legislative body which can hold hearings and consider countervailing factors to make the judgment. For example, Professor Rothstein from University of California, Berkeley said that with respect to tenure, there are trade-offs. If you have more time, you get more information. On the other hand, if you were to take 10 years, you would keep bad teachers in longer, and you wouldn't be giving job security to other people. So I think when you have those kinds of trade-offs, it's probably better suited for a legislative body than for the judiciary.
Great.
Can I respond? Can I make one response to that?
Sure.
You know, it's interesting that in this case, the unions argued that all of these issues should be decided by the legislature, who, by the way, they play no small role in influencing. But a few years ago, when the unions didn't like the dismissal statutes the way they were then comprised, because teachers were expected to share in the cost of dismissing a teacher at that time, the unions ran to the courts and argued that the statutes were unconstitutional, and they won. And the California Supreme Court said that no, school districts must bear the cost for teacher dismissal statutes because you're otherwise violating the constitutional rights of teachers. So, you know, the unions know how to argue it both ways. If they don't like the laws, then it's a judicial problem. If they can get the laws passed that they do like, then it's appropriate for the legislature to be passing those laws. And by the way,
unlike your clients, I'm sure, Judge.
And by the way, the state of California, in that same case that was arguing over the constitutionality of the dismissal statutes a few years back, the state of California argued to the California Supreme Court that if the school districts are forced to bear the cost, the very high cost of teacher dismissals, that students would be harmed because the school districts would have no choice but to leave ineffective teachers in place. That was the state's argument then. And they're right. That's exactly what happened. But now the state of California, for some reason, is on the other side, arguing that the dismissal statutes don't cause harm to students. And so you can see that the causal relationship that Jim describes is not hard to see. If you have a system that doesn't allow school districts to manage out teachers that aren't teaching, that harms students. Very simple.
Great. Time for a few excellent questions from the audience. Does the Constitution recognize a right to education? Should it? In other words, should the Rodriguez case be overruled? Interesting to get both of your takes on that.
Well, I think the California Constitution does, and my understanding of the federal Constitution is that it does not. I would be fine if the federal Constitution did. I think education is incredibly important to our society.
And I agree. This is something we agree on. I think the state Constitution of California does, and the federal courts, at least as of now, have said that it does not. Although there is some, it's not as black and white as people like to make it out. San Antonio v. Rodriguez was a 1970s Supreme Court decision where the court said that it will not recognize basically the same right that California recognized in the same context. So they wouldn't recognize a right to equal educational funding. That was the issue that was before the California Supreme Court. And they said that the Equal Protection Clause does not protect that. But in subsequent Supreme Court cases, like the Papasan case, the Supreme Court has explicitly said that it has not yet ruled on whether there is a federal constitutional right to some minimally adequate level of education. So that remains an open question.
A question to each of you. For you, Josh, you claim that teachers are the most important factors in education. What about breathtaking levels of segregation that your state perpetuates? This seems at least as important.
And that's true. And what I actually said was that teachers are the most important in-school factor affecting education. So factors that occur out of school, like poverty and segregation, of course, are of vital importance. But the question is, what happens when the student arrives at the schoolhouse door? Because unless we are willing as a society to completely write off children of poverty, which I don't think we're willing to do, nor should we be willing to do, then we have a responsibility to take whatever comes into the schoolhouse door and educate that child to the best of our ability. And that's where the California school systems are failing, and that's where they're failing in large part because of the statutes that we've challenged.
Great, and two related questions for you, Jim. Other occupations do not have tenure. Why should teachers have this protection? How should tenure be determined? As a law professor, I think the answer is self-evident, but perhaps you have a different take.
To follow up on the other factors, Professors Goldhaber and Hanashek, whom they called, indicated that overall teachers only have about a 6% impact on a child's success, and that many of these other factors have more of an impact. So the Fisher case is coming up before the U.S. Supreme Court. I'm hoping that the U.S. Supreme Court sees a window to say that having diversity in schools and allowing some integration of schools can be permitted under the Constitution, because I think that would help a lot. All the studies seem to indicate that having diverse schools help. Tenure, it has to do with academic freedom, and you have school boards that are run by parents who have their own views of the world. We had testimony about somebody who taught near an Air Force base, and she was supposed to teach 8th grade religions, and she wanted to teach Islam, and she said that a lot of the service people were asking for her to be fired, and the only reason she wasn't fired was because she had tenure, and the principal said that she was protected. So I think it's incredibly important for academic freedom.
Just a point of correction on that. The teaching Islam as well as teaching evolution are part of the state curriculum. So the teacher cannot be fired for teaching the state curriculum. And that same teacher, never described any actual attempts to fire her. So the notion that she was somehow protected and by these laws is simply incorrect. And as to the teachers that you mentioned earlier who supposedly were afraid to reveal their sexual orientation, California has laws to address that. You can't fire a teacher for being gay, nor should you be able to fire a teacher for being gay. So there are other ways of dealing with those issues. To the extent that you're a believer that academic freedom is really important in teaching second graders, then there are other ways of dealing with that issue.
Ladies and gentlemen, America's town hall, like U.S. Supreme Court arguments, do have to end on time. But I need to tell you how honored I am that the National Constitution Center has united the best minds on both sides of this most contested of all debates, and you've heard how civil and substantive the discussion is. We had some unexpected agreement, unexpected to me at least, about the fact that the U.S. Constitution should protect a right of equal educational access, some vigorous and respectful disagreement about how this right should be applied. We are taking this show on the road. We have an incredible series of debates called Traveling Town Hall Debates, and we're going to go to California and debate the merits of this case out in the Bay Area. If we're lucky, we'll be able to reconvene this extraordinary team. What I want you to do now, we have some cocktails, and we're going to continue the conversation over drinks. But if you support and are moved by the incredibly substantive discussion you've just heard, become a member of the National Constitution Center. Rebecca Bolden is out there. She will sign you up at whatever level. This is just a privilege to be able to be a convening space for this extraordinary discussion. Look forward to continuing it. Please join me in thanking our panel.
Thank you all.
Really great.
Yeah, absolutely.